Okay, we're ready.
Good morning, Judge, or afternoon.
Good afternoon.
Yes.
Good afternoon.
Good afternoon.
Okay. Ms. Clifton, when are we ready?
This is case number 19001-213 in Pulse Physical Therapy, LLC versus State Farm.
Good afternoon, council appearances for the record.
Your Honor, Sylvia Manster on behalf of intervening plaintiff Pulse Physical Therapy.
Good afternoon, Your Honor. Anderson Grandstaff on behalf of defendant State Farm.
Okay, Mr. Grandstaff, you can proceed. One question, and I tried to find it and I couldn't. What happened with Mr. McGinnis's claim?
With Mr. McInnes's claim in this suit,
Yes.
it was resolved at case evaluation.
Okay. All right. Okay, you may proceed.
Thank you, Your Honor. This is the hearing on State Farm's motion for summary disposition based on the fraud committed by the underlying claimant. In this case, it's Lorenz McInnes. As we set forth in our brief, Your Honor, there have been numerous inconsistencies and outright contradictions in the statements that Mr. McGinnis has made to State Farm and his providers following the subject accident that purportedly occurred in August of 2018. We've also provided an ADA report that clearly lays out not only that the accident could not have happened as has been alleged, but that the damage to the vehicle was in fact fabricated in order to make it seem like an accident had happened. The day after the accident allegedly occurred, a contact of intervening plaintiff contacted State Farm prior to the referral that supposedly led to Mr. McInnes treating with them, and asked State Farm if the file was open for billing. When McInnes did finally present to the intervening plaintiff for treatment several days later, he presented at the same time and at the same location as his fellow occupants of the vehicle. The treatment that he received was excessive and was full of contradictions in and of itself. Eventually, State Farm conducted an IME of this, and during the IME, Mr. McInnes made other contradictory statements, and he further informed the IME physician that some of his injuries weren't actually related to the purported accident at all. They were caused by a backpack that he was supposed to be wearing for his employment. We also conducted surveillance of Mr. McInnes, which showed that he was acting completely normally. He was shooting hoops, setting up a basketball hoop. We know that he was working at that time as well. He continued to treat with Pulse Physical Therapy for another 3 months or so after that. We've filed a reply brief in support of the MSD in response to some of the arguments that were raised by opposing counsel in their response. And if I could just touch on a few points. One thing I thought was notable was that the Hatcher case that was cited in opposing counsel's brief, it's really difficult to overstate how weak the case was for fraud. And I don't have any doubt in my mind as to why the Court of Appeals ruled the way it did on that case. That case involved inconsistent statements about one prior complaint of lower back pain that arose 6 years before the accident at issue in that case, as well as several things that the Court of Appeals found were either taken completely out of context or weren't material to the claim. In this case, we're dealing with someone who has inconsistently failed to describe the events of the subject accident, which is directly relevant to the claims, and has been unable to provide consistent statements within days of the accident occurring. This is simply not a good comparison case, and it seems to be one where the case for fraud was quite weak. Here we also have objective evidence that the accident couldn't have occurred as alleged. At this point, and over the last week, we've filed similar motions in several other courts, including Oakland County and in Wayne, and we've gotten dismissals for cases related to several of the co-occupants, Cornelius Fuller. And I think that when you look at it, the evidence here is quite straightforward, that this is a fraudulent claim, and that that fraudulent statements were made with the intent to induce State Farm to provide benefits that Mr. McInnes was not entitled to. Because intervening plaintiff's claims are derivative claims, they must also be dismissed for that reason.
Ms. Mansour?
Yes, brief response. I'll primarily rely upon the briefs, as I'm pretty sure the court is well versed in it. First off, they are not derivative claims. They are different claims. They are separate claims due to the assignment. The assignment makes them separate claims, and any misrepresentations occurred, any alleged misrepresentations occurred afterwards. Second of all, a few of the points are complete red herrings. For instance, the fact that him and the other individuals that he knew treated at the same provider, that happens, you know, especially when those individuals know each other and they refer them to those places. They say, hey, this is where I'm going, you should go too. That's not out of this world. Third, Your Honor, it's simply inconsistencies. That's what it is. And Your Honor knows where I stand on this. Your Honor has heard these arguments before from me, from our clients, from our office. It's a matter for the jury to figure out. I do believe that that Hatcher case is on point. And in addition, Your Honor, as I'm pretty sure this court is aware, there was an even more recent case that came out on July 9th, which is set for publication, which is Hay Dow versus Farm Bureau, which is currently number 345516 on the Court of Appeals docket, that specifically states that inconsistencies are not enough to dismiss a case on fraud. Once suit is brought, what is truth and what is false is a matter for a jury or a judge acting as fact finder. And I am more than happy to brief this case a little bit more thoroughly. If the court wants to have both sides brief it, that's completely fine, but this is not enough for MSD at this point, Judge.
Your Honor, may I please respond to 2 points raised in that?
Yes.
The first, Haydaw, the holding in that case was very specific, and it also only applied to statements made after litigation had been initiated, as opposing counsel just stated. All of the inconsistent statements here arose before litigation was initiated. The statements to the IME doctor, the statements made during the EUO, that has no application to this case. Secondly, regardless of the existence of an assignment, these are clearly derivative claims. These are claims being brought by the name of Lorenz McInnes. It has nothing to do with whether there's an assignment. The assignment might be the mechanism that granted us the rights to recover on behalf of McInnes, but that still is contingent upon McInnes having a right to recover. These are derivative claims. If it is found that Lorenz McInnes committed fraud, then regardless of what the assignment says, the claims of intervening plaintiff must be dismissed.
Right, but the thing is, we haven't made the determination. There hasn't been a determination that there was fraud on the part of Mr. McInnes, because generally speaking, we get to this point if in fact, you know, the court previously ruled that there was fraud that was committed on behalf of the claimant, the injured party, and then the court usually finds that, and it's usually consistent with Daewoo, that, you know, if in fact we had granted summary disposition as to the claimant, then any other individual would stand in the same shoes, but we don't have that here. This is a situation where you're asserting the fraud in the first instance, and it's not really as to, you know, I think it seems like you're sort of kind of backdooring it, because we didn't have a summary disposition that was granted as to the claimant here, and that's generally the situation where the court does go ahead and grant the decision. I know that it appears that in some instances, the Court of Appeals may be moving away from granting or upholding judgments where there's an issue of fraud. And I had a case yesterday, and I think there's an unpublished decision. I think it's McCosta, and they're starting to, and that was decided. I can't remember when it was decided. It was recently, within the past 6 months. Everything's starting to move together.
Blur.
Yeah. So I don't know if it was March or June. I can't remember, but it was recently. And there's another case that was on the opposite side of the fence. But those were all dealing with situations whereby the summary disposition was against the claimant. In this situation, it's not necessarily against the claimant. It's there hasn't been a summary disposition against the claimant. That will make a stronger case if the evidence is taken in light most favorable to the non-moving party. But here it's still questionable. There's a lot going on. There's a lot of moving parts, and irrespective of what's taking place in other courts, in Wayne County, in Oakland County, whatever, because there's so many moving parts, I don't feel that there's a sufficient basis to grant summary disposition against Pulse when there hasn't really been a grant of a summary disposition against the claimant in the first instance. So the court is going to deny the motion for summary disposition.
Thank you, Judge.
Thank you. We have a settlement conference, so let me conclude this hearing, and then we'll deal with the settlement conference.